Good afternoon. Welcome to the Civil Justice Academy. Today's program, sponsored by the Law and Economics Center at George Mason University's Antonin Scalia Law School, is an update on the debate over third-party litigation finance. I'm Donald Koshin. I'm a professor of law at Scalia Law, as well as the executive director of the Law and Economics Center. I'll be moderating today's discussion. The Law and Economics Center is committed to developing original, high-quality law and economics research and educational programs like the one today to further enhance an understanding of economics and to provide information that informs the public policy and legal debates nationwide surrounding these issues. Thanks for joining us in that endeavor. Our panel of experts today each come with impressive backgrounds, and they'll be engaging with and evaluating the work that they've been doing in third-party litigation funding. I'll keep the intros short to reserve as much time as possible for our expert comments as well as for your Q&A. And I recommend that you click on the email that you received from the LEC or on our website at masonlec.org, where you can click on the bios and get a full airing of the expertise and experience of all of our panelists. Today's panel includes Jordan Schwartz, who's counsel at Skadden Arps, Slate, Meagher and Flom, LLP. Then we have Daiwai Chin Feman, who is the Director of Commercial Litigation Strategies and Corporate Counsel at Parabellum Capital. Jeremy Kidd will follow up Daiwai. He's a professor of law at Drake University Law School. And finally, Bob Goodlate, former member of United States Congress and former chairman of the House Judiciary Committee, will close out the opening remarks. Each panel will speak for about 8 to 10 minutes in their opening remarks, and then we will have some inter-panel discussion followed by audience Q&A. If you do have a question, you can submit it at any time during the presentations. Just look down at the bottom of your screen at the Q&A section, the Q&A button, click on that and put your question in the box. Please identify yourself as well as keeping your questions sufficiently short so that they can be amenable to this online format. With that, I'm going to turn it over to Jordan to get started on understanding what's happening in the debate over third-party litigation funding. Jordan?
Thank you, Donald, and good afternoon. There's really no dispute that third-party litigation funding, or TPLF as I'll abbreviate it, has grown by leaps and bounds in the US over the last decade. Although it's impossible to measure the precise dollar amount invested yearly in US litigation, one recent article conservatively estimated that the figure is around $2.5 billion, while another source put it at $5 billion. Not only has the amount of TPLF investment skyrocketed, but the types of lawsuits that are being funded have expanded as well. Once reserved for business-to-business litigation in purely individual matters, TPLF has seeped into the mass tort and class action arenas. TPLF is being used to institute lawsuits over product liability, false advertising, securities fraud, data breaches, contract disputes, patent disputes. It's pretty much everywhere. But unlike virtually every industry, funders are essentially unregulated, and there is no general rule requiring the disclosure of TPLF in a given case. Litigation funding disclosure rules are in effect in only a handful of jurisdictions. The District of New Jersey last year promulgated a rule requiring basic disclosures in all cases. Parties have to reveal the funder's name, whether the funder's approval is necessary for litigation settlement decisions. The Northern District of California has a disclosure rule in class actions. And at the state level, Montana recently enacted a disclosure bill that would require the production of funding agreements themselves. And we're closely monitoring whether the governor of Louisiana will soon sign a similar bill into law in the next couple of weeks. A growing number of individual judges are also starting to require some form of litigation funding disclosure. Just recently, Judge Yvonne Gonzalez-Rogers of the Northern District of California orally asked each attorney seeking a leadership position in the recently established social media addiction MDL proceeding to divulge in open court whether he or she is using or plans to use litigation funding. And last year, Chief Judge Combe Connolly of the District of Delaware issued a standing order requiring the same kind of disclosure as is required in the District of New Jersey. Although these instances show that judges are becoming aware of the pervasiveness of litigation funding, they also demonstrate that judges would benefit from a uniform rule of civil procedure, or statute on how to obtain this critical information and what to do with it. At the federal level, lawmakers in both the House and the Senate previously introduced a bill in the last Congress called the Litigation Funding Transparency Act. The bill would mandate the disclosure of funding agreements in class actions and MDL proceedings. A pending proposal before the Advisory Committee on Civil Rules would amend Rule 26 and require the disclosure of litigation funding agreements in all civil cases. A uniform disclosure statute or rule of procedure would benefit our civil justice system in a number of key respects, but I'll focus on just two that have been generating significant recent attention. First, disclosure will ensure that plaintiffs have control over the litigation that is theirs. Funders repeatedly assert that they do not control or influence the litigation strategy, that they are essentially, quote, passive investors. But most funders have not come forward with any evidence of that, presumably because doing so would require producing the agreements that they wish to keep secret. The reality is that the handful of agreements that have been publicly disclosed do not bear that narrative out. A very recent dispute involving Burford Capital, the largest litigation funder in the world, is illustrative. Cisco Corp is a plaintiff in a series of antitrust class actions against some of the nation's largest food suppliers. And just a few years ago, Burford invested over $100 million in Cisco's claims. When Cisco reached settlements with some of the suppliers, Burford balked, deeming the offers to be too low. Burford then went to an arbitration tribunal and obtained a preliminary injunction enjoining Cisco from executing the settlement agreements. Cisco has filed a petition to vacate that arbitration order on the ground that it violates public policy, that the agreement, the funding agreement that essentially gives Burford veto power over settlement decision-making, violates public policy. So essentially, Burford is forcing Cisco to litigate claims that it would like to resolve expeditiously outside court. If that is not blatant control, I don't know what is. Burford's alleged conduct only came to light because Cisco went to court to challenge an arbitration ruling. The court and the parties have a right to know whether this dynamic is at play in any of their cases. And disclosure of funding agreements is the only way to accomplish that fundamental objective. Now, Burford and other funders have claimed that the Cisco case is an outlier. But this is not the first time that even Burford has influenced or controlled litigation it has bankrolled. Over a decade ago, Burford invested over $4 million in a notorious environmental pollution class action against Chevron in Lago Agrio, Ecuador. The funding agreement in that litigation provided control to the funders through the installment of nominated lawyers. These were lawyers selected by the plaintiffs with Burford's approval. Disclosure would also shed light on whether courts are being used in a manner that may be harmful to our national or economic security. Although the precise extent of foreign investment in U.S. litigation remains unclear, we know that foreign investment is happening. For example, we know that Burford has partnered with the Sovereign Wealth Fund, according to its annual report. Another funder, Therium, has stated that it has a similar relationship with an unidentified sovereign wealth fund. Foreign actors, including potential adversaries, could attempt to exploit our litigation system to advance their home industries or companies, or to even disrupt our political system. Former Attorney General Michael Mukasey highlighted these concerns in a September Wall Street Journal op-ed. In that piece, Mr. Mukasey highlights that about a quarter of all U.S. patent cases are financed by third parties. And as he explains, the vast majority of patent litigation does not advance the interests of inventors or consumers. Most patent cases are filed to enrich investors, including potential foreign governments. It is not inconceivable that foreign governments would seek to exploit the secrecy of our litigation funding system to harass and drain the resources of U.S. companies. Louisiana Senator John Kennedy from Louisiana wrote a letter to the Chief Justice and to U.S. Attorney General Merrick Garland raising these concerns. So these are just a couple of reasons why litigation funding agreements should be disclosed as a matter of course. And finally, I'd close by noting that even some funders have started embracing limited disclosure. Last November, one of our esteemed panelists, Mr. Feeman, and another executive parabellum published an op-ed indicating potential support for reasonable tailored disclosure requirements. And so that's a very encouraging sign that TPLF will become more transparent. Thank you.
Thank you, Jordan. I want to remind the audience that you can use the Q&A button down at the bottom of your screen to ask any questions. We'll have an opportunity for those questions to be presented to the panelists at the close of opening remarks. With that, I turn it over to Dai Wai.
Thanks. Since 2014, the Chamber of Commerce and other detractors of litigation funding have manufactured a series of supposed problems with litigation funding to justify disclosure. These range from the frivolous arguments about frivolous litigation to the now hollow fear-mongering about baseless national security concerns. The defense and insurance lobbies seek to use disclosure as a means to obtain prejudicial protected information that courts have overwhelmingly found to have zero legal relevance absent special circumstances. In the words of Professor Todd Henderson at the University of Chicago Law School, disclosure is used as a Trojan horse. These problems identified by the Chamber have been and will continue to be debunked, including by independent bodies such as the Civil Rules Advisory Committee, which has studied funding for years and declined to rule-make, to the Government Accountability Office, which issued a 50-page report on litigation funding last December and did not recommend regulation and gave zero credence to the national security argument. Indeed, just last night, Louisiana Governor John Bel Edwards wrote in his letter vetoing Senate Bill 196, the Litigation Financing Disclosure and Security Protection Act, quote, "This piece of legislation is clearly a pretense designed to gain a litigation advantage under the guise of promoting transparency in litigation and protecting national security. The proposed structure has one desired outcome: to deter legal finance companies from doing business in Louisiana. The only beneficiaries of this would be wrongdoers who can simply outlast victims because they have greater financial resources. The Louisiana legislature should make every effort to level the playing field for all of those who are forced to litigate disputes. Instead, this bill operates to give one side in litigation advantage to the detriment of those who are seeking to recover from injury, economic damage, or property loss. As such, it will not become law." Unable to identify any real problems, opponents of funding nevertheless continue advocating for forced disclosure. They argue disclosure is necessary because without it, there's no visibility into the wrongdoing that could be occurring. This is the classic solution in search of a problem. The national security issue perfectly illustrates why. It stems from a Chamber of Commerce report written by Michael Leitner of Skadden Arps. But Mr. Leitner has admitted that the concern is hypothetical at best. At last year's ILR summit, Professor Jaffer of Scalia Law asked Mr. Leitner, "So we know, right, that at least some foreign governments or at least their sovereign wealth funds are involved in this third-party litigation financing. Is that right?" He responded, "Well, we certainly suspect it, okay?" He later said, "We don't really think that third-party litigation financing is this backdoor to get classified information per se in the way that the US government classifies it." Similarly, earlier this year, Senator Melanie Scheibel, the chair of the Nevada Senate Judiciary Committee, asked David Meyerson of the ILR to support the national security point. She said, "I appreciate we don't know what we don't know, and there's certainly some information that we're missing, but you've just stated on the record in this hearing that China and Russia are funding litigation in the US to gain a competitive advantage in the technological field." Mr. Meyerson responded, "For the record, I did not attempt to imply that we know for certain that China and Russia are looking to use this system. We know they are adversaries, and this could be one of the tools in their toolbox." Now, you may have noticed that I referred to some opponents of disclosure a few moments ago instead of all. The reason is because in April of this year, 13 Republican state attorneys general sent a letter to Senator Grassl and Representative Issa, urging them to, quote, reconsider their support for the Litigation Funding Transparency Act, which failed to progress when proposed in 2018, 2019, and 2021, and, quote, any other form of forced disclosure. The letter states, quote, "We know from experience that forced disclosure laws like those proposed by the LFTA and similar forced disclosure bills, which would mandate that parties in litigation, without a discovery request or a ruling on relevancy or privilege, disclose the details about their private financial arrangements, can easily become political weapons and bureaucratic tools for delay and harassment, restricting freedom of speech and association, and eroding attorney-client privilege and other important confidentiality rules." The letter closes by stating, "We welcome the opportunity to work with your offices to find alternative ways to improve our civil justice system while protecting the privacy of litigants." So where does this leave us? This panel is about an update on the debate about litigation funding. Is it a debate at all? The funding industry and its opponents, such as the Chamber of Commerce, remain polarized, and I expect we will remain that way. So will it ever end, or will we continue living in Groundhog Day? I acknowledge that the industry is opaque. To be clear, litigation funders do not oppose disclosure because we have something to hide. It's because we have something to protect. This is no secret to the Chamber of Commerce and others who are seeking disclosure. It has been pointed out time and again, yet they continue to propose unbounded, unlimited disclosure that would do nothing to address the potential prejudice concerns. I believe, as Jordan pointed out from the article I wrote, which I encourage everyone to read because I am running out of time, that there are potential middle grounds here, but that requires an actual debate, and it requires folks to not engage in that debate in a disingenuous manner. If the chamber truly seeks to scratch certain itches, which can be legitimate, such as judicial conflicts of interest, and even this national security concern, which is completely baseless and unsupported, there are middle grounds for limited disclosure. The catch is that any disclosure must be accompanied by something that protects against prejudice, and that is what I argue in my article. What folks may not recognize is that there are many people on my side of the aisle, we'll call it, who are actually pro-disclosure. There'd be many benefits of disclosure as long as it can occur without prejudicing litigants' cases. Litigation funding improves access to justice, and it would be very ironic if by taking funding, it would lead to disclosure that actually harms the litigants' claims. Let me take a moment to address the situation involving Burford and Cisco that Jordan mentioned a few moments ago. The way that Jordan describes it, Burford provided capital to Cisco and did so in a means which provided with the ability to control Cisco's litigation. That's actually not true. If you look at the case and know anything about it, you know that Burford provided substantial capital to Cisco under a contract that contained no control right whatsoever, and in fact disclaimed that control right. So what are we even talking about here? Well, Cisco, it turned out, breached the agreement and assigned away a substantial portion of the collateral, which was going to form the basis of the proceeds for Burford Capital's investment. After it did that, it sought to retain that capital, so the parties settled their differences and amended the agreement. They provided Burford with a limited settlement veto right. This is not a control right. It did not enable veto to control strategy, control litigation, make settlement offers, or do anything of the like. Instead, it is something that enabled Burford, under only very limited circumstances, to object to a settlement. Now, before they executed this amendment, Cisco told Burford what its settlement floor was. It said, under no circumstances will we settle below this amount. Now, once Cisco assigned away the collateral, it no longer had much incentive to continue litigating the cases. So to protect against the moral hazard of Cisco abandoning its claims and keeping Burford's money and therefore achieving a $140 million windfall, the parties agreed that Burford could have a veto right. This would prevent Cisco from walking away from its claims. So what happened? They amended the agreement. Burford obtained the veto right, and then Cisco went and tried to settle its claims below its own stated settlement floor. Burford predictably objected to that. And how did Cisco respond? It said, well, you can go and get an injunction to stop us. Otherwise, we're going to sign the settlement agreement and you're going to lose the value of your claims. The Burford-Cisco story is about the material breach of a litigation funding agreement. It's not about control by litigation funders. It's not about false representations made to the market. I know that members of the chamber and other detractors like to state that litigation funders say, you just have to trust us. It's actually not true. And I think there's opportunity for limited disclosure that could address this. So first of all, there has been plenty of disclosure, particularly in light of the District of New Jersey Local Rule 7.1.1. District of New Jersey is the second busiest civil docket in the country, and there have been hundreds and hundreds of disclosures in District of New Jersey. What's interesting is that the vast majority of these disclosures do not indicate that there's funding at all. In fact, hundreds of thousands and possibly millions of litigants' dollars have been spent disclosing to the court that there is no funding. And of the limited circumstances where there is funding, no issues have been identified. There are also limited disclosure rules or automatic disclosure rules in Wisconsin and West Virginia. No one is pointing to any problematic disclosures there. There are also other examples of litigation funding agreements available online. Jordan pointed out that the ones that he's aware of have these problems. Perhaps that's because he's focusing on a specific subset that have come out over the past 10 years, which are very atypical and all have their own kind of story to them. But the vast majority of agreements that are in the public domain actually do disclaim control. One only need go on Edgar and search for the names of litigation funders, and you'll find publicly disclosed examples of contracts which do have disclaimers of control. So I think that with the polarized debate, it's actually a great opportunity to have a discussion. I look forward to that later, and I welcome other panelists to try and propose productive solutions to the issue where we can possibly meet in the middle. Because as a member of the funding community, I can say unequivocally that we'd really like to move past this disclosure issue so that we can focus on doing our jobs and helping litigants prevail on their meritorious claims. I have several ideas and proposals that I'd be happy to hear feedback from Jordan, Representative Goodlot, Professor Cochin, and Professor Kidd. And one that I'd like to discuss, which I mentioned in NYU conference a few months ago, is the idea of limited key terms. And this could be an automatic disclosure rule that I'm only speaking for myself here, but I anticipate that there will be less resistance to it. And this is meant to show that truly we do not have something to hide here. Really, it's about prejudice and we have something to protect. Limited disclosure rule could be that similar to District of New Jersey Rule 7.1.1, there has to be a disclosure when there's litigation funding. It could state certain things, such as who is the funder. That would resolve any conflict of interest concerned with the judge. Whether the funder has control rights. We could have in there whether the funder has shared any information or could share it with any hostile foreign sovereign wealth funds. That indeed would be non-objectionable because, as the Chamber of Commerce has admitted, there is no evidence of this occurring whatsoever. And at bottom, that agreement is actually quite farcical. It would imply that, or would require there to be a conspiracy between not only a litigation funder and its hostile sovereign wealth fund investors, but also with its counsels who, as Adam Mortara pointed out, would need to be violating protective orders in order to provide the information in violation of those orders to a funder who would then be providing them in violation of many regulations and duties, including to its own investors, to a sovereign wealth fund, all for the purpose of undermining national security. I don't like to downplay national security concerns, but in fact, this argument implies that litigation funders are somehow traitors to our country at bottom, and I think there's an issue with that. Returning to my idea, we could have limited disclosure in cases which addresses these concerns, and to the extent there's any question about what the agreement actually says, that limited disclosure could say that to the extent there's any conflict between what's stated in this disclosure and in the actual agreement, this limited disclosure controls. I think that would absolve any legitimate or arguably legitimate concerns about funding and finally enable us to move past this issue so we can focus on something else. Thank you very much.
Thank you, Daiwai. And once again, audience, please do use the Q&A button at the bottom of your screen to submit any questions. We're going to turn it over next to Jeremy.
Yeah, thanks to Donald and the LEC for putting this event together. And I'm going to take a step back particularly from the Burford Cisco dispute and take a little bit broader view, because my perspective on the issue of third-party litigation financing tends to be that it's complicated and that there are no easy solutions. When I say it's complicated, I mean there's a wide variety of financing products. It's not just Burford. It's not just the commercial side. There are commonalities between them, but there are also many differences, and those differences confound any effort to identify and implement an easy solution. As I hope we can all keep in mind, imposing easy solutions to solve complex problems guarantees some significant unintended consequences. The highest level distinction in litigation financing is between the consumer side and the commercial side. And what we've heard so far today has been largely the commercial side. The consumer side is largely designed to help consumers with expenses in the lead up to trial. A broad definition of consumer litigation finance would even include contingency fee arrangements between plaintiffs and their lawyers. We don't think about the issue that way, and no one is arguing that we should reinstitute old bans on contingency fee arrangements. But I think it's helpful to remember that they are included because it helps us understand what the consumer side of the industry is designed to do, fill in the financial gaps so that the plaintiff can more easily prosecute their claims. Of course, consumers have more to deal with than just paying their lawyer as they pursue their legal claims. They have medical bills, which they didn't anticipate. They have more standard expenses like housing, food, and other essentials to pay for. Often they can't work much, if at all, in the lead up to trial. And the trial itself will obviously require some time off work. And every one of these circumstances creates budgetary shortfalls. Litigation financing can mitigate those shortfalls. Some financing products are general, providing a check to the plaintiffs for whatever expenses arise, and others are more specific, like a financier paying directly for necessary medical screening and procedures. Sometimes the shortfall that's being covered is between current budgets budgets and expected post-judgment budgets. In other words, plaintiffs might have a vision of what life will be like after they win, and they want to start living that life right now. So rather than seeking litigation financing to meet unexpected expenses, they want to give their friends and family a better Christmas now, even though they haven't yet established a right to any of the money to pay for it. And financial prudence might caution against that course of action, but it's not clear, one, whether the government should be imposing prudence on those plaintiffs by restricting their access to litigation financing, or two, whether it would have any practical effect, since the plaintiffs could likely fill the budgetary shortfall with a credit card. That latter option might even be worse from a consumer protection standpoint than litigation financing. Moreover, if financial prudence is our underlying principle, it's not clear how we would curb those more frivolous examples without also inhibiting plaintiffs from paying for necessities like medical care, housing, food, and so on. So policymakers need to be very careful to differentiate them, and most efforts to regulate litigation financing have not shown an inclination to be nuanced and detailed about the process. Now, the reason I take a little bit of extra time talking about the consumer side, even though most of the move recently has been on the disclosure side, is because almost all of the examples end up being commercial examples. And yet most of the, I have friends in the consumer, on the consumer side, and they consistently send me the bills that are being passed in the various states. And they say, we've been told this is mostly about commercial litigation financing. Do you think this affects us as well? And I look at it and say, of course it affects consumer litigation financing. There's no differentiation involved. So the debate that is currently ongoing, and it's not just about disclosure, it's about a whole host of other regulations, some of them proposed by the industry as sort of model legislation, but others not. It would affect this consumer side, even though most of the examples that are given are the Burfords of the world, those big examples that really do sound pretty awful when presented in a particular way, but they affect individual people who are just trying to live their lives. Anyway, moving on to the commercial side, the goal of financing is still broadly the same: to fill budgetary shortfalls, usually related to cash flow, but also adding in a large portion of risk mitigation. But the recipient on the commercial side can either be a plaintiff or a defendant, and will typically be more sophisticated than the average consumer plaintiff. The range of possible options in the commercial space is also widely varied. A broad definition could even include simple business loans from a bank to a law firm. Most of our debates don't include that kind of standard financing, but the principle is largely the same. In fact, looking at the commercial side through an objective lens reveals that most of the industry is merely a slight modification of standard financing vehicles. It's not some nefarious conspiracy. They range from simple loans to hedge fund investment to insurance products. Anytime there is an asset with future value, the person who owns the asset has potential income waiting for them in the future. Given the natural tendency of human beings to want things now, it's not surprising that people will be willing to trade off some of that future potential income for a current payment. Sometimes it takes the form of a loan with an interest rate payment. Sometimes it takes the form of a direct sale or part of that right to future income. The most straightforward version of this latter phenomenon is actually something called probate funding, which doesn't really fit easily into the normal consumer categories. In probate funding, a putative heir can just sell all or part of their property interest in the estate to a financier. In the case of a full purchase, the financier takes the heir's place in every respect moving forward. That is, I mean, if that happened broadly, I think we could all agree that might be pretty troublesome, but it seems to be isolated to probate funding. The distinction between loan and investment really complicates attempts to regulate the industry. Some financing products are structured like loans with a fixed interest rate. Most, however, are structured like that investment, with the financier taking an ownership interest of sorts in the outcome of the trial. That's fundamentally different from a loan, particularly in that the financier assumes far more risk with an investment than from a loan. With a loan, there's always the risk of default, but that risk isn't directly tied to the outcome of litigation. With investment financing, the risk is tied to the ability of the litigant and the lawyers to obtain a positive result. And importantly, this isn't entirely a question of the merits of the legal claims, because the personality and self-discipline of the client often have a big impact. We have individual plaintiffs who do crazy things, and everyone who's ever dealt with an individual plaintiff knows that. And halfway through trial, suddenly your client completely destroys your ability to prosecute the claim, even though you should win on the law and the facts. Sometimes, as Daiwai pointed out, sometimes you have commercial clients who just breach their contracts in the middle of trial, and that can be a problem as well. That's a risk that faces the litigation financier. So that's one of the big problems, being able to, you have that counterparty risk. You can't control unless you can't control the client if you're the financier unless you have something in the contract. And Jordan's worried about that. I would be worried about that too. But in most cases, the financier has no contractual right to control the litigation. So the financier cannot act to mitigate the risk once the financing has been provided. Both sides of the industry, commercial and consumer and commercial, are independently complex, and the differences between the two sides raise that complexity even further. Purportedly simple solutions are pretty much all we hear about these days, but imposing one-size-fits-all solutions on a complex system is rarely the path to success. I know that the Chamber's members believe that when the government attempts to regulate them with one-size-fits-all solutions. I worked on Capitol Hill when Bob was a member of Congress, and I always respected him because he understood that basic principle. Now, I'm not blind to the legitimate concerns that people raise against litigation financing. Simple economics principles teach that when you reduce the price of something, people buy more of it. Litigation financing reduces the price that litigants have to spend on litigation. So it shouldn't surprise anyone if litigation financing leads to more litigation. I think that's the Chamber's primary concern. Unfortunately, most critics don't stop there and don't ask the important question: is more litigation always a bad thing? As long as litigation provides benefits, the answer to that question has to be no. If we trust the fact that we have a litigation system, adversarial in nature, that's supposed to get us to truth, then it's at least possible that we have too little litigation, with too much wrongful behavior going unpunished and a lot of inefficient costs being imposed on society. Now, of course, we can't have both. We can have too little and too much. We can have too little because the costs of litigation keep legitimate claims from getting to trial, and we have too much because there's too much frivolous litigation. But the answer to that second part is not to keep the legitimate claims from getting there. It's to actually address the nature of the law in question. It's not clear how demands for disclosure do that. It may be that disclosure is good for limited purposes, but those limited purposes ought to be addressed, and the rest of litigation funding ought to be regulated after a reasoned policy debate by people who actually want to figure out where the costs, where the benefits are, and I think that's how we should approach it.
Thank you, Jeremy. Once again, we have the Q&A button at the bottom of the screen. We'll be getting to those questions very soon, but first we will close out our opening remarks with Bob. And Bob, you are muted.
Muted now. First of all, Donald, thank you very much for inviting me to participate in this program, and for the Center for Law and Economics at Scalia Law School for putting on this program. I think it's a very pertinent topic. Third-party litigation financing has exploded in recent years, and the entry into the market further and further by private equity firms raises a whole host of issues that need to be addressed. But I'd like to pick up where Jeremy left off, because I think the real question that should underlie both the courts, and judges have stepped in this area, as has been cited by Jordan, and in some instances, legislatures have jumped in, and in, I think, other instances, I think we're going to find an interest on the part of executive branch agencies wanting to know more about who may be funding people appearing for the International Trade Commission, for example. But in any event, the core issue for me, and I think for all of these entities, should be: what is the impact of this on the fair and efficient administration of justice? We're not talking about private equity firms investing in a new traditional marketplace where they're going to invest in something and hope to enhance the creation of a product and enhance the growth of a company, the creation of jobs, and everything that attends to that. That is the principal purpose, in my opinion, of private equity investors, like other investors as well. But when you're talking about investing in litigation, you're talking about investing in not a marketplace, but in a courtroom and in a system of providing justice. And that justice is founded upon the rule of law. It's founded upon the judge hearing the evidence presented, but also primarily upon being heard by a jury, which is ultimately going to make the decision. And that jury, they're not experts in the marketplace, nor are they free market operators. They are charged with a very solemn responsibility of finding out how to apply justice to a particular circumstance. So when Daiwei makes the point that third-party litigation funding enhances a number of people's access to the courts, that's a valid point. I don't disagree with that at all. But it is not always the best place for somebody to make a bet on the outcome of something, and the only interest of the third-party funder is in winning that bet. It is not based upon the underlying goal of the court to resolve the matter. So when you talk about Jeremy's concerns about the explosion of litigation that occurs, one of the aspects of that is that there's much, much, much less incentive for settlement if there's a difference of opinion between the party being funded and the party providing the funds. And that is exactly the core problem in the Cisco case with regard to Burford Capital. Cisco is that we're talking about SYSCO, Cisco, the food distribution company, not CISCO, the company that manufactures hardware and software for the technology sector. Cisco had a problem that with the companies that provide meat products to them, beef and poultry and pork products, and they felt that they were colluding to fix prices against them. So there are solutions to that under our federal laws and in some instances state laws as well. And Cisco wanted to undertake that and they obtained financing. The amount of money that Burford has now publicly stated they put into this is staggering, $140 million. It seems like that is more than necessary to prosecute the litigation and may entail some additional considerations. And Daiwei is also right that there's an underlying contract dispute here that's at the core of the matter. And I don't know who's going to be right in that. What I do know is that Cisco would probably very logically say, I'm going to need to continue to buy meat products from these same people that I'm suing on into the future. And that's not going to be the case for the third-party funder, for Burford. Burford sees that in antitrust cases, particularly price-fixing cases, you can get treble damages. So they're very concerned and very optimistic in going into that Cisco is going to prevail and they're going to get huge amounts of money. But Cisco wants to get the issue resolved so that they can get lower prices for meat products on into the future, more than they're concerned about the amount of money recovered in this instance, because they are going to be a continuing customer of those suppliers. So does the court have a legitimate interest in knowing more about what that arrangement is? Does the court have an interest in knowing that there's a third-party funder? And if so, what the agreement is, what the who might be the underlying funders of it? In some instances, yes. In some instances, no. I agree with Jeremy. This is a very, very complex area. But if you look at what's happened in Delaware, where the chief judge of the U.S. District Court there, Colm Connolly, has imposed disclosure requirements, you're finding that he is using this as a tool for the efficient administration of justice. That court obviously receives an awful lot of contract litigation, awful lot of patent litigation, because so many corporations are incorporated in the state of Delaware. So it's a natural place for a lot of these suits. It's one of the highest courts in terms of the number of patent cases brought. And so look at some of the interesting things that have happened there. First of all, some of the people that he's required to make third-party funding disclosure have gone to the federal circuit, which oversees these types of intellectual property cases. And in every single instance, they have backed up the judge and said, yes, you're entitled to ask for this information. That has resulted in many of these folks leaving the court. The number of cases pending before the federal court in Delaware has declined. So he solved a problem there in terms of not having the resources to handle an exploding number of cases that are brought. And they're not brought, by the way, for the most part, by companies that feel that they've been infringed. The significant majority of them are brought by non-practicing entities. Some people also refer to them as patent trolls. And in those instances, what is happening is They don't want to disclose because people may be embarrassed. It may be a competitor who thinks they can harm some corporation by bringing these patent suits. It could be a sovereign wealth fund. We don't know, but we certainly should be entitled to ask and find out to address that. But the fact of the matter is, his docket has been significantly reduced because of that requirement. And then if you look at one really interesting case that certainly would cause a lot of interest in finding out the reasons for it, Intel Corporation, sued by BSLI Incorporated, a non-practicing entity, actually secured a large judgment against them in Texas in the federal courts there, which seems to be dissipating because the Patent Trial and Appeal Board has ruled that they are not valid patents. But be that as it may, BSLI in their case on another set of patents in Delaware, rather than make the disclosure of who was funding them, they gave Intel Corporation a license for something that Intel said, we don't need a license, but if you're going to leave this court and go somewhere else to sue us, no, we're not going to agree to that. So they have a license from the company, and they gave up a $4.2 billion claim in order to not disclose who the third-party funders were in that case. So I think that this needs to be looked at from the standpoint of some circumstances you need to have disclosure. I think there are many cases of third-party funding where you wouldn't have that kind of disclosure. If you're suing the government and you're a nonprofit and you're receiving funding in order to take on the federal government, I'm not at all sure that if there's no profit interest in the outcome of the case, that the third-party funder needs to be disclosed. But I think that in other cases, it does need to be disclosed. And when it's disclosed, it may lead to other questions, and the court should have a more standardized approach to how to address this. And sometimes legislators need to help with that. So I think it's well worth looking at what the Congress is attempting to do in this area. Thank you.
Thank you very much to all of our panelists for a great introduction to the topic and to the ongoing debate. And with that, we have just a few minutes. We do have quite a few questions in the queue that I'd like to get to, but I'd like to ask our panelists whether or not they heard anything that they from the other panelists that they'd like to respond to, or if they have a question that you might want to pose one of the other panelists. So Daiwai, I see your hand up. Why don't you go ahead and we, I'll just remind all the panelists, we do want to reserve some time at the end for the Q&A. Sure,
I'll be as brief as I can. On Burford and Cisco, I think there's some confusion about what's actually going on here, including about what the money was for. I encourage everyone to read the article I wrote in Bloomberg Law on this, which debunks a lot of the arguments that have been made. And I encourage folks on the other side to respond to the viewpoints that I've expressed based on an actual view of the record. But in case anyone doesn't know, Burford is currently winning in the arbitration. The arbitration panel held that Burford did have the ability to hold up the settlement because it did violate the party's agreement, and that party's agreement was enforceable. And again, it's not an agreement on control. It's the ability to veto a settlement that is unreasonable. And this one was demonstrably so, as it was below the stated settlement floor and done in circumstances where Cisco otherwise had no incentive to continue litigating as a result of its own misconduct and breach. This is not a typical scenario. It's very unique. You can also read the op-ed that executives from Burford put in the Wall Street Journal explaining this. On Judge Connolly in Delaware, Bob, thank you for bringing that up. I just want to put a little nuance on that point. I actually don't characterize what's happening in Judge Connolly's courtroom as a concern about third-party litigation funding. I actually think it stems from his local rule 7.1, where he demands disclosure all the way up the chain of any investor in any vehicle. And the reason why the LSI and Intel resolved the way that it did, I don't think had to do with disclosure of who the funders are. I think it had to do with patent assertion entities, which I think patent trolling is very different than third-party litigation funding. It had to do with hesitancy of, in general, disclosure of limited partner interests of the GPs, which is something that's not typical and violates privacy, and is something that I think the Managed Funds Association and others strongly contest.
Well, let me just say in response to that, I don't disagree with all of it, but I certainly disagree that patent assertion entities or trolls are not funded by third parties. They are in many, many instances funded by third party litigation funders, by hedge funds and others. And it's a growing and serious problem. So I think that Yes, there's also the very valid point that the judge needs to know whether he has a conflict. There can be conflicts amongst other parties. I'd ask the question in the Cisco case, because I don't disagree with your characterization of what's going on there, nor do I know who's going to win the outcome of that. But I think that there's a legitimate question about whether the judge going into the case should know that there was an inherent conflict at the outset, because there's no question in my mind that Cisco, as an ongoing business that's going to continue to deal with these companies, has a different interest in the outcome of that case than Burford Capital has in the outcome of that case.
Can I just step in here, because I know Daiwai has had a lot to say on this, and I would just take a step back, and I think we need to be mindful of the fact that from the beginning of kind of litigation funding reaching the shores of the United States, funders have taken the position that they never exercise control or influence. We can talk about how we got to the veto provision in this case through an amendment of an agreement. And I'm not disputing the characterization, the kind of procedural history of what happened. But the bottom line is no one is denying, no one is disputing that Cisco is not able to settle claims that it wants to settle. The claims belong to the plaintiff under basic principles of professional responsibility. Burford is not bound by the rules of professional responsibility, and the entire episode just serves to highlight why basic disclosure, not unmoored disclosure, which I think was the term that was thrown out today. We're asking for basic disclosure, basic transparency that is analogous to the transparency of the financial resources that any defendant has to produce at the beginning of a case under Rule 26 with its insurance agreements.
Let me let Jeremy get in here for a sec. He's got his hand up and wants to chime in.
Yeah. No, I think like all of these are absolutely legitimate concerns. I mean, there are concerns about whether or not Burford is trying to exercise control over claims that belong to Cisco. I will point out that this is effectively Cisco attempting to have the courts save Cisco from its own contracts. They knew that in advance, and I'm always concerned when I see the law drifting in a way that attempts to save contract counterparties from the choices they made. I'm a little more sympathetic when it's the court trying to save consumers, although even that gets paternalistic and problematic in the long run, as we've seen, with the unconscionability and arbitration clauses and the like. But it's particularly galling if we were to see a general trend where a company like Cisco, that has some of the best lawyers around, sign a contract, understanding this is the potential outcome, and then complain on the back end, oh, this is against public policy. Whatever happened to the doctrine of unclean hands, right? So there's a problem with that there. But I will say, again, it's legitimate concerns, and particularly the way, Bob, the way you phrased it, I think your argument, I think, is reasonably sound. I just would say that, Bob, when you argue when your argument seems to implicate not laws, right? So the chamber is encouraging states to pass laws mandating disclosure, right? And that I don't think is justified in any way, shape, or form, because in a case where the worst case scenario is not playing out, that disclosure can actually be used against the plaintiff, who it can be a consumer plaintiff, someone who got a medical lien, and suddenly it's being used against them in a way that is completely unfounded. Whereas if it were left up to the discretion of the judges, right, then they would be bound by they would be subject to appeal whether or not they properly balance the probative nature of the evidence against the prejudicial nature, right? They would be required to make that balancing, and they could be subject to reversal, and the case could be thrown out.
Well, Jimmy, let me just respond. It's a valid point, but let me just respond that judges sometimes need to be prompted by both rules that they can adopt within their system, but ultimately those rules are the province, they are the jurisdiction of the United States Congress. And so we've had a problem, with judges not disclosing conflicts and not even looking at potential conflicts. And that caused quite a stir. And you're familiar with the stories in the New York Times and so on. But I think the chamber's position on this is that in some instances, disclosure should be required by law, both in the state courts and in the federal courts. If it can be accomplished by rules that are put in place in those judicial systems, great. But if not, then they think legislators and the Congress should step in and act.
And I would just say I really like Bob Goodlett version 1, which was 10 minutes ago, and the Chambers version is slightly different. I like your version. I side with you. I don't side with the Chamber on this.
Well, let me also say that I think the underlying interesting point about the Cisco dispute, and I agree with you. As I said before, I don't know who's going to prevail, but I think there's a legitimate question of how much more information the court should have going into a dispute like that, because there's effectively two plaintiffs with two different interests in that type of case. It's not just, are we going to get, as much money as possible here? And I think that for the efficient administration of justice, more needs to be known in general about third-party litigation funding than the third-party funders want to disclose. And so that's the core of this issue.
If you can take it in just 30 seconds, then I want to turn to
very briefly. We've heard opposing viewpoints. Everyone's been respectful, which is great. The question I continue to have, though, is I've made a proposal here on behalf of my own viewpoint that I'm in favor of limited disclosure to address the arguably legitimate concerns, such as conflicts of interest, control, et cetera. What is the response from Chamber Bob or Bob or Chamber Jordan or Jordan or Professor Kidd? What is the response to the proposal? Okay, let's have these things automatically disclosed, but anything beyond that, such as anything that could be potentially prejudicial, is presumptively irrelevant absent a special showing of good cause. Can that be lived with? Because I don't see any reason, unless the true goal of disclosure is, as Professor Todd Henderson of UChicago said, a Trojan horse, which I tend to agree with. But if this is a real debate and the concerns that have been expressed are actually real, why can't disclosure be narrowly tailored to those concerns and limited so that our prejudice concerns, which are very valid and linked to access to justice, are addressed?
Can I just,
Jordan, if you can take 30 seconds.
Yeah, 30 seconds. I think it's great that we have someone from Parabellum who is advocating limited disclosure and basically saying that the New Jersey rule is a good rule and is a good blueprint.
Not what I'm saying. Only if it said and everything else is off limits.
Well, it didn't. I mean, it said you can seek discovery for good cause. And I think that is a reasonable approach. That's a reasonable starting ground. I personally think that you do need to have the agreements, because that's the only way you're going to know if there are improper control provisions. But let's get together and let's kind of try to build some consensus on a starting point, which I think the New Jersey rule, at least in large part, is.
We could leave the floor open for discussion, I think, for hours and continue to talk. I think we've gotten a really great airing of some of the key topics to be thinking about and the discussions that need to occur in the future. Let's spend our last 8 minutes making sure that we hear a little bit from the audience. And so I'm going to start with John Karakari, who asked, what kind of research do you think can be done to determine if there's too much or too little TPLF? So there's a lot of academics who are on this call listening in, as well as other interested parties who would be interested in doing research. What do we not know? How can we learn more? What kind of research would you like to see produced by scholars and those who are practicing in the field?
I think that's a great question, and I think that maybe Daiwai can shed some light on this, but maybe scholars could talk to third-party litigation funders. Maybe they could do it with some protection for anonymity, but find out more details about exactly what he's saying, and that could be shared with judges and courts and legislators and so on. But I do think that part of the problem with studying this is the very lack of transparency that exists now.
Just a plug for the GAO report, which did interview a number of funders and at least attempt to collect data.
If I could point out that even if we have too much, that there's an overlap there, confounding effect, that we may have too much litigation funding because there's too much litigation overall, right? That we have this overlying problem that there is too much litigation in addition to being too little. There are a lot of frivolous claims that come. The only way to stop that is to make sure the laws are tightened up, make sure judges actually follow the law, right? But if you tighten that up, then you're far more likely to avoid the problem of too much litigation funding, because then the benefits of litigation funding, just allowing legitimate claims to get to court, is going to be far easier to accomplish. So
I agree with that. I think that's a good point.
I think everyone should just keep in mind that there are there are quite high barriers to entry to this space. There's only a few funders who operate at least on the commercial side in the US. And at least my perspective is that the concern about how pervasive funding is dramatically overblown. It's actually very niche specialty finance industry, and I think only a handful of cases actually get funded each year by each funder.
And that actually raises.
I'd just like to jump in here for a second on the pervasiveness of funding outside of the commercial context. We are starting to hear from plaintiffs' lawyers in mass tort proceedings who are expressing serious concerns about litigation funding, driving up meritless claims, and that has a deleterious effect on legitimate claimants because it takes a lot longer to resolve a mass tort. If you're going to have meritless claims that are parked in an MDL, defendants are much less likely to settle them. And so you've got this distorted impact. And I think you're going to start seeing more and more plaintiffs' lawyers. I'm hearing anecdotally, and I think you're going to start seeing it. And I think that that's going to be something to watch.
Let me turn to the question from Robert Lamborn, who is proposing potential solutions here. So you all have proposed some, and here's another. As noted, one size fits all solutions fit no one well. On the other end of the spectrum, fully bespoke is too expensive. But are there any easy solutions that could work pretty well in most cases at low cost? For example, providing small, medium, large, extra large as off-the-shelf sizing, I guess, labels that you might put on the level of funding that would be useful to judges or other litigants, possibly treating for-profit TPLFs differently from not-for-profit entities, and barring foreign persons or entities altogether. Are some of these that Robert Lamborn has suggested potential solutions?
I think we need to think about what we're trying to solve for. I don't know that I've heard any real actual concerns. If you're trying to solve for sovereign foreign adversaries, I think we can solve for that pretty easily. But I think you also got to keep in mind that it's not a legitimate concern. And if that really were the concern, you'd need to solve for a lot of other problems. Wouldn't the most rational way for a hostile foreign government to get control over litigation to be invested in an actual party to the litigation, as opposed to a non-controlling, 3 steps removed litigation funder who is not even under the protective order in the case? I mean, it's just completely irrational. But in any event, yes, I think that there is a way to solve it. And I think it is potentially through a disclosure rule as long as it's limited, as I keep saying. And this is something that Judge Polster did in the opioids MDL, which funders largely appreciated and deemed sensible, and could also happen. Of course, it will need to be accompanied by the catch that everything else is presumptively irrelevant. Otherwise, disclosure is just going to lead to continual satellite litigations, which are just going to drive up expense and serve as a tax on litigants and raise the cost of funding and make access to justice even harder to obtain.
Anyone else on those ideas?
I will just point out that most of the laws that have been implemented make no distinction between commercial and consumer. I mean, even if we couldn't do, small, medium, large, XL, that there should at least be a recognition that some of the concerns that are raised, they're just different, right? There's very little consumer protection that needs to occur in the commercial space because most commercial actors are represented by counsel. They're fine, but there's also very little risk of things like, there's no national security risk because someone's got a medical lien for a CAT scan that they had, right? So some of these we could clearly just kind of differentiate the two. Unfortunately, almost every law that's been passed never differentiates the two, and it just slaps a one-size-fits-all solution. So
we do have some safe harbor carve-outs, like 500K exemptions in some of the state laws.
Yeah, you're right. There are some, but it rarely says make that distinction, which is an easy distinction to make between consumer and the commercial side. So we could start parsing it down, even if we couldn't identify exactly where the XL, L, M, and all of those distinctions would be.
Just to say one word about the consumer side of this, you're right that there are much lower barriers to getting into court in terms of the amount of funding needed. But the collateral question is, what is the plaintiff in those cases, the harmed person, giving up? In addition to the contingent fee arrangement they have with their attorney, now they also have a contingent fee, or the attorney has an additional contingent fee and therefore is asking for a larger fee from the plaintiff in order to have the funding to get into court. And these can get very, very exorbitant because the people who are providing third-party financing are not in this to help that plaintiff get the recovery they want. They're in it to make money.
Yeah,
So we are, Jeremy, unfortunately, we're just about at the time. So I'm
Sorry.
going to give you a chance to use your last 15 seconds. So if each of you, we have 1 minute left, if each of you can take just 15 seconds, a true 15 seconds, and inject the final point you'd like to make, or the one thing that you hope everyone will walk away thinking about for the rest of the afternoon and the weekend, having listened to you so far. So why don't we start with Jordan? And I'll go counterclockwise on my screen to Jeremy, then to Daiwai, and then to Bob.
Thank you, Donald, and thank you, panelists. I'm very encouraged that there is some. It does seem like there is some agreement here that some basic disclosure is in order, and I think that's great, because 10 years ago, I think there was no consensus that litigation funding should be remotely transparent. So I'm encouraged by that.
Jeremy.
Yeah, basically, this is a very complex issue, and it's not going to be solved by easy solutions. And litigation funding meets a need, and we probably ought to spend our time figuring out why that need is there, rather than trying to bludgeon those who step in to fill the need.
Daiwai.
I'm optimistic as well, but I want to make sure that my comments aren't mischaracterized. Limited disclosure could scratch a lot of the itches that have purportedly been identified, but it must be accompanied by a recognition, which is consistent with the case law and the study by the independent bodies that evaluated this, that potentially prejudicial information must be off limits, and that must be a condition of any automatic disclosure regime. That will require a concession by the chamber that we're going to meet in the middle, and that litigation funding is not going to go away. If that's the true goal, and that's why disclosure is truly sought, then there's no potential for compromise. If the chamber and others are realistic and being honest about things like conflicts of interest, and those are legitimate, true concerns, those can certainly be addressed, and then we can move on. But again, we need protection for these litigants against potential prejudice.
Well, I would just say that the ultimate goal here should be the fair and efficient administration of justice, so people with legitimate claims can get into court. So therefore, disclosure, in my opinion, is necessary. And sometimes when you have some disclosure, that would lead to further disclosure, depending upon what issues arise. I think there needs to be more disclosure in general, so that those scholars that were referred to earlier can do some more effective studying, and so can legislators and judges themselves. So I hope that this does lead to some greater transparency. And I think when that comes about, then Congress and courts can make a better decision about the appropriateness of third-party litigation funding, depending upon the type of case that we're talking about.
Well, thank you again to all of our panelists, and thank you all for listening in. We do want to be mindful of your time. We always agree that we'll end this as close to 1 as possible. We know that an hour is not nearly enough to do justice to all of these issues, but we do hope that you leave us a little better informed than when you came here at noon. And I think that all of our panelists have helped us accomplish that goal. So once again, thank you for joining the Law and Economics Center at George Mason University's Antonin Scalia Law School for our Civil Justice Academy installment today. Please join us again on July 21st for our Civil Justice Review of the last Supreme Court term. We will have an exciting panel together to discuss the most consequential cases of the past term and to think about their implications for civil justice. So we hope to see you on July 21st. And with that, I bid you all a wonderful afternoon and a great weekend. Thanks again to everyone for joining us.